advice. I have got how many minutes? Anyway, let me proceed. I want to start from the outset by declaring that I totally support this amendment bill. The National Land Commission Amendment Bill, sponsored by the Honorable Owen Bayer, the Deputy Leader of Majority. Madam Speaker, and I am supporting this bill as a matter of principle. Matter of principle. Having looked at the section of the Act which is being amended, I can in fact say, without a fear of contradiction, that those sections, both section 14(1), both section 14 subsection 1 and section 15, okay, of the Act were, in my very considered view, unconstitutional ab initio. And why do I say so? Honorable Speaker, whenever Parliament is called upon, and I hope the Leader of Majority will listen to me. The Leader of Majority, I hope you will listen to me, because I'm raising very fundamental issues here that may be of interest to you going forward. So I am saying that, for the benefit of the Leader of Majority, that I am supporting this amendment bill, the National Land Commission Amendment Bill, sponsored by the Honorable Owen Bayer, as a matter of principle. And I've said that now, looking at the sections of the National Land Commission Act that the Honorable Bayer is proposing to amend, I can say without the fear of contradiction that, in my very considered view or opinion, those sections were unconstitutional ab initio. Yes. And why do I say so? Whenever Parliament is called upon to enact laws, to give effect to particular provisions of the Constitution, it cannot be that same law becomes a limitation, becomes a hindrance to the very Constitution or very provisions of the Constitution that it is seeking to effect. Because if you read Article 67 of the Constitution on the powers and functions of the National Land Commission, especially Article 67, sub-article E, Article 67, 2E, where the functions of the NLC are, among others, to initiate investigations on its own initiative or on a complaint into present or historical land injustices and recommend appropriate redress. These are powers that were given to the National Land Commission by the Constitution. The drafters of the Constitution and Kenyans generally gave these powers to the National Land Commission through this Constitution. And then you go to the National Land Commission Act and you find a very, very glaring attempt to, in fact, change the Constitution, if you ask me. Because if the drafters had intended that this function would only be performed within a specified period of time, then nothing stopped them from specifying so in the Constitution. The Act goes ahead at section 14, subsection 1, to suggest that the Commission shall, within 5 years of the commencement of this Act, on its own motion or upon a complaint and so on and so forth, undertake the function contemplated under Article 67(2)(e) of the Constitution. Whereas the Constitution has left it open. An ordinary Act of Parliament purports to enforce a limitation, a time limitation. What was the wisdom of the House when it enacted this legislation? What was in the mind of the House? Was the House of the view that this historical land injustices would have been dealt with conclusively within 5 years? That the Commission would have been able to deal with all historical land injustices within 5 years? Was that the thinking of the House of Parliament when it enacted this particular statute, law? Okay? My submission is that the House erred. The House made a great error in purporting to limit the time frame within which historical land injustices would be addressed by the National Land Commission. And therefore, Honorable Speaker, the only remedy that is available, and we are lucky that the courts have not been moved to declare this particular section of the Act unconstitutional. And therefore, Honorable Baya has given us, and Kenyans generally, a golden opportunity to right the wrong that was occasioned through the enactment of this statute law. Because the only remedy really for this ambiguity, the only remedy for this illegality, the only remedy for this unconstitutionality is to adopt the amendment being proposed by the Honorable Owen Baya and allow the National Land Commission to undertake its mandate, to execute its mandate, to perform its functions as clearly contemplated under Article 67, sub-Article 2 of the Constitution. Because otherwise, if we were to assume that for sure now, going by the provisions of this Act, no more historical land injustice cases would be dealt with, then how would we then want Kenyans to deal with them? If by this limitation under the Act, the NLC would no longer undertake its function under 67(2)(e), then who would then perform that function? Who? If the NLC is now barred from performing that function of 67(2)(e), by dint of the provisions of the NLC Act, then who would then be called upon to perform that function? That's the question we should be asking as a House. Are we saying, therefore, that we go back to who? Because under the current Constitution, no other authority has got that function. Under the current Constitution, no other authority or person can perform that function under 67(2)(e) other than the NLC. It's not the President, it's not the Cabinet Secretary for Lands, it's not anybody else. It's not anybody else. Do you want the Kenyans now to go back to the rule of the jungle and start now squaring their issues physically? That if I feel that injustice was occasioned on me, a land injustice was occasioned on me, and the body which is mandated by the Constitution to do it, to address it, is not able to address it, then what do? Do I square it out with the person who I feel has caused me the injustice? So it is only logical, really. It's only logical that the amendment being proposed by Honorable Owen Bayer be endorsed, be approved in totality by this House. And in fact, this process should be expedited. Because as we speak, I know there are cases which are pending before the NLC. Cases which perhaps have come from elsewhere, or cases which they have initiated on their own volition. I know my friend Honorable Karoli Mundi is itching to speak to this. I'll be pleading that we give him time to say something after this, so that I get to know what is it that he has in mind about this particular matter. But from where I sit, Madam Speaker, from where I sit, I don't think we have got any other route to cure this problem. So I want to plead with you, honorable colleague members, that let's expedite this bill. Let's just adopt it like yesterday and have it assented to, for us to go back to where we should have been from the very beginning. Allow the NLC to perform its functions. Otherwise, with those very many remarks, Madam Speaker, I support. Thank you.
Majority Leader.
Thank you, Honorable Speaker, and I also rise to support this bill by the Deputy Leader of Majority, who is also the very good member for Kilifi North, and my very good friend. Honorable Speaker, this bill, as the Leader of Minority has said, is quite progressive. And indeed, I want to agree with the Leader of Minority that in the first instance, the particular provisions in the law, as it were indeed unconstitutional, because you cannot limit what is expressly provided for in the Constitution through statute. And that is what I think Parliament had done, and I believe on hindsight now, because myself and the Leader of Minority were in that House in the 11th Parliament, was erroneous. And he said it's only fools that don't change their minds. And since we are not fools, as a House, we ought to change our minds and align the statutes to the Constitution. And indeed, Honorable Speaker, you know, there are many land issues in this country, and not just historical land injustices. And I know there are those who are in fear that these particular provisions may give the National Lands Commission the power to look into private land matters and all that. But what is of greater importance to me, Honorable Speaker, is the disposition of public land. And Honorable Speaker, it's good that you are sitting as a temporary speaker today, because you have been the chairperson of the Lands Committee in this House in the last Parliament. And you know the number of land parcels around the country that have been taken up by cartels, who are now taking advantage of the absence of these particular provisions in the law, that people can take up public land and subdivide it and corruptly process titles through the Ministry of Lands, and take up land that is otherwise public land. And there are many instances across the country, including in my own constituency, Honorable Speaker, where cartels have taken a chunk of over 100 acres of land that formerly belonged to the Kenya Forestry Service, subdivided it, and over the years have been trying to sell that particular piece of land to innocent third-party buyers. Honorable Speaker, you can imagine the tragedy that befalls people when you buy land that had title, that you went to the Ministry of Lands, searched that land, and found it to be a clean title, only to come to learn later that the particular people who sold the land to you initially ought not to have been legitimate owners of that land, Honorable Speaker. And it is only an independent commission that can fix some of these issues. The rot that has bedeviled the Lands Ministry over the years, Honorable Speaker, is not something that can be fixed by the ministry itself. They need a third eye, and that third eye is the National Lands Commission. And the drafters of our Constitution in 2010 had every reason not to trust the ministry alone, but to create another independent arm, an independent commission in the National Lands Commission, to oversight and see what is being done on matters pertaining especially to public land. And Honorable Speaker, I want to restrict myself to the issue of public land, because that is where the rubber meets the road on matters to do with the theft of land, Honorable Speaker. And by denying when this Section 14 and Section 15 of the National Lands Commission became redundant or lapsed within the 5 years after commencement of the Act, Honorable Speaker, the National Lands Commission has been left as an impotent body. They will see today Kimani Ichungwah grabbing public land. They know it is public land. Because I am in a position of influence, I will get my way through the Ministry of Lands, process titles of public land, subdivide that public land, and dispose it off. And the National Lands Commission will do absolutely nothing. Honorable Speaker, it is that we want to correct, and I must commend the member for Kilifi for having this bill done.